but a couple things I do want to mention, even though they're not on the slides. One of them is what I refer to as a modification notice. That's going to require employers to provide notice of any material modification to their benefit plan 60 days before the plan, the modification is implemented. And that's going to be effective 2 years after the law was passed, so March of 2012. So just another notice requirement, entirely separate from this notifying employees about the exchange. It's a notice. It requires a little more. Right now, that's not the case for the most part. Employers can make a change to their health plan and kind of tell employees about that change after the fact. Under this new notice requirement, there will have to be this advance notice if it's a material modification to the plan, and material modification could be an enhancement to the plan, or it could be a subtraction from the plan.
For those health insurance brokers out here, I think that means that people are going to have to start renewing their contracts 2 months in advance. Otherwise, when you change carriers or when your coverage changes, how can you satisfy that 60-day requirement?
Yeah, yeah. That's a good question. The question was, what will be the penalty if you don't satisfy that 60-day notice requirement? I haven't seen any reference to what penalty, if any, there would be. It may just be, it's possible there's no penalty at all, because actually under ARRA, which already has notice requirements in terms of a summary plan description having to be provided to the employees, and a summary of material modifications having to be provided even on an after-the-fact basis. Right now, there's no penalty under ARRA for failure to provide a summary plan description to an employee. Now, if you fail to provide, and the employee could sue you and force you to provide it, and you could incur the cost of expense of defending that, and so, better just to give the notice what you're required to give. But it's possible there's no penalty at all, other than just the fact that the law requires you to do it.
And I'm not sure someone would be able to sue the employer and say, this change in the plan shouldn't apply to me because you didn't give me notice of it, because under ARRA, you can only sue for the benefits of the plan.
Well,
so I wonder,
yeah.
I don't know, I don't think, it didn't modify ARRA, this law, so.
Well, there were some aspects of this law that did modify ARRA, so
right.
It's not clear whether this is part of it or not. But so bottom line, I don't know what the penalty, if any, there would be. But believe me, employers are going to certainly try to comply with it, even if there's no monetary penalty for failure to comply with that notice requirement. Moving out of the group health insurance arena, just briefly here on the individual health insurance side. Individual insurers will, beginning in 2014, for the first time, be prohibited from discriminating on the basis of eligibility. The same kind of HIPAA non-discrimination rules that have been in place since 1996 for group health plans are going to be extended over to individual health insurance policies too, so that based upon someone's health condition, for example, an employer won't be able to discriminate them, as to eligibility. That is a kind of a no-brainer. In fact, I'm a little surprised that has such a delayed effective date until 2014, to be honest. Guaranteed issue, another important provision of the healthcare reform, but with a delayed effective date until 2014. So that's when a lot of these major changes are coming into place, is 2014. And all insurers, whether it's on the group health insurance policy side or the individual side, are going to be required to issue and renew health insurance policies on a guaranteed basis. But enrollment can be limited, though, to open enrollment and special enrollment periods. So it won't necessarily be people moving in and out on a monthly basis. You can limit it to certain open enrollment or special enrollment periods, but insurers will not be able to, even if someone was initially healthy and then later on got unhealthy, they won't be able to, they'll be assured of being able to continue on the individual policy or the group policy regardless of how unhealthy they might get. They can't be canceled the way they can be by an individual health insurance issuer right now.